Hi there, my name is Steve Medlin. Good to talk to you. When you fail to make a will, you have no estate plan. The state makes your will for you. It is not what you want for your estate plan. I will talk with you about some items you might not have thought of. Concerning your will, those things will be cookie cutter wills, internet wills, deathbed wills, out-of-state wills. Estate planning means you are taking charge of your assets, and for those things over which you have responsibility. Assets such as your possessions, your money, matters of responsibility like your children. Those personal items, well, many of them are heirlooms. They're keepsakes. They mean something in your family. For instance, this watch is the one my father wore as a GI back in World War II, just an army soldier in Europe doing his job. Priceless, will never leave my family. Do you have heirlooms like that in your family? I expect you do. Your failure to make a will causes a family fight that can last for generations. Your assets can wind up in the hands of some real renegades. The horrendous expenses of courtroom fights over assets, plus the gargantuan time it takes sitting in court, can cripple you and your family. You have seen it happen in your own family, probably in your own community as well. I know of you have heard of other attorneys who will do quickie and cheapy wills. There is nothing more expensive than a quick and cheap legal fix for your problems. Other attorneys will often use fill-in-the-blank forms, templates into which all the needs are hammered. The square peg of your life is pounded into the round hole that fits into a computer program. I don't do cookie cutter. Your situation, your individual situation is unique. I will look with you and uncover the real heirlooms in your family. I work with you to craft a unique solution to your unique needs. Working closely with you, I will ask a lot of questions, including the right questions, to get to what you are needing for your real assets, your real needs. Those heirlooms, special circumstances that need to be handled in a way you want them handled. Let me caution you, an internet-generated will or a form book-generated will is too imprecise, too broadly drawn. It is taking the square peg of your estate plan and pounding it into the round hole of a very generalized method. The internet will won't do for you. It is drawn to cover many, many situations and states, and drawn to cover so many types of areas. It's just not for your unique individual situation. When you use an internet-generated will or a form will drawn from a book to create your handwritten will, your words are those in your legal document. Well, they're the words of imprecision. However, the courts will take those documents, take those words, and put precise legal meanings to your words. The court will take your words and force them into legal holes, changing the meaning of what you intended. Let's use the proper legal terms in your legal documents right from the beginning. Make the proper will that accomplishes your purpose using precise legal terminology. If your will was drafted out of state, it is probably not valid here in North Carolina. Our laws are different here. In North Carolina, that out-of-state will can fail very, very easily. Then you are right back in the position where the government is writing your will for you. That out-of-state will has failed here in North Carolina. Your property, your assets, your heirlooms, your responsibilities are now handled the way the state tells you they will be handled, not the way you want it. You may not be aware that your minor children will be affected by your will. The quickie and cheapie will put your children at risk. When your will fails, your minor children could be placed in any home, anywhere by our court system. That is not what you want. You want to tell the court system where your children will be living and who will be raising them when you are not here. Let me tell you something else about minor children you might not have thought about before. Should you die and leave minor children, by the time those children reach 18 years of age, they're going to receive your full estate, completely, all dumped in their laps. That's typically not what you want. I surely did not know how to handle money when I was 18 years of age. Your accumulated estate is intended to take care of your children and educate them. But you're not living. You're not there to take care of them. Often there is a real need for minor children to establish a trust that can disperse your assets while your children are too young. You choose who will administer that trust as trustee. You establish the goals. You establish the terms under which that trust will operate. You also choose the age at which your children will receive those assets. I'm very good at drafting an estate plan, but far too often I'm summoned to the hospital to prepare an estate plan, find my client suffering from greatly diminished capacity to communicate. As your attorney, I need to be involved early enough in the process to be helpful in that legal service is meaningful or sometimes just possible. None of us knows what tomorrow holds. What is the right time to call an estate planning attorney? Call me today.